Now, this included tariffs on China as high as 145%, 50% tariffs on Brazil and India, 35% tariffs on Canada, 25% tariffs on Mexico, 30% tariffs on South Africa. The list goes on. According to the U.S. Treasury, in September, tariff revenues totaled more than $31 billion, bringing the total year-to-date figure to $215 billion. Now, recall, tariffs are paid only after goods have entered the United States, which means that the U.S. importer pays them. Those costs get passed on to you, the consumer, or companies so-called eat the costs. Or sending nations simply reduce how much they export to the United States. In other words, that revenue isn't necessarily coming from abroad. It's going to the U.S. Treasury from consumers right here and domestic companies. Now, all of this tariff-specific language actually ignores a huge legal question. And that is, are President Trump's tariffs even legal? Does he have the constitutionally conferred power to slap tariffs on the world? Because the tariffs themselves are not an issue. The U.S. uses them all the time. The issue is, who has the legal power to levy tariffs? The president or Congress? Well, tomorrow, the United States Supreme Court will hear oral argument over exactly this question. Here's President Trump on Sunday talking to reporters on Air Force One.
I think it's the most important decision, one of the most important decisions in the history of our country. Because without tariffs, without our being able to use tariffs freely, openly, and in every way, we would suffer tremendously from a national security standpoint. The national security of our country is at stake. It's the biggest, I think it's one of the biggest decisions in the history of the Supreme Court.
President Trump added on Truth Social that same day, quote, "If we win, we will be the richest, most secure country anywhere in the world by far," all capital letters there. "If we lose, our country could be reduced to almost third world status. Pray to God that doesn't happen," end quote. But the Supreme Court's decision could transform more than just trade policy or the economy. And in this point, President Trump was right in that clip you heard. If the highest court allows the president to issue unrestricted tariffs without congressional approval, it would be one of the greatest expansions of executive power in this country's 250-year history. It would essentially give the presidency a powerful and unchecked tool that could be used against any country, any industry, any business, whenever and however the president likes. So today, we're going to examine the arguments the court will hear for and against this historic expansion of presidential power. And we begin with Lori Wallach. She's the director of the Rethink trade program at the American Economic Liberties Project. That's a nonprofit in Washington focused on the concentration of economic power. She's also author of The Rise and Fall of Fast Track Trade Authority. And Lori has more than 30 years of experience in international and U.S. congressional trade battles. She's testified on this issue before Congress dozens of times. Lori Wallach, welcome to On Point.
Thank you very much.
So, first of all, elaborate as much as you can what you understand about the president's argument for the dire necessity of tariffs. I mean, you heard in that clip that he talked about, well, it's for national security. I mean, what more has he or his administration said that would support this national security argument?
Well, the rhetorical arguments and then there are the legal arguments. Mm-hmm. And the administration effectively is squabbling over what kind of tariff authority it has, because it's not an all or nothing at stake here. There are lots of clearly delegated tariff authorities where Congress has said if other countries are cheating on trade, for instance, dumping, selling below the cost of production, that's dumping, mm-hmm. or if a country is threatening national security and what they're doing with trade, or there's a product we need for national security. Congress has delegated authority for presidents to use tariffs, and the Supreme Court has tested those delegations and found them to be fine. Mm-hmm. At issue in this case is whether a president has entirely unbounded unilateral authority under a particular statute called the International Emergency Economic Powers Act, or IEPA. And President Trump and the administration want that totally unchecked, unbounded authority because it basically provides rights to, as you said, unilaterally leverage any kind of threat or reward to any political ally or enemy, to any country, to any industry. Yeah. And that is an unbound tariff authority that is in question in this court case.
Okay, so we will really leaf through in detail IEPA in just a few moments, right? Because that is the central act that, as you said, will be debated before the justices tomorrow. But I just want to go back over what you said here a minute ago. The examples that you gave in terms of, there are instances which the U.S. has in the past used tariffs for literally for what the president is saying now, for protecting national security. But in every one of the cases you just talked about, or sort of test cases you talked about, Lori, you also said Congress says that in that case, issuing a tariff is, or levying a tariff is appropriate. The implication being that ultimately Congress has to provide the approval for tariffs.
Correct. So it's worth stepping back a little bit. The U.S. Constitution has one of the sharpest checks and balances in the entire document with respect to tariffs and trade. And folks, sometimes don't remember that in a way our country's independence was spurred along by a trade war. The Boston Tea Party was the colonial protest against King George's unilateral imposition of tariffs on tea and other imports. And the founders, with that enormous power of tariff in mind in writing the Constitution, in enumerating Congress's authorities, put not one but two explicit clauses of exclusive constitutional authority to Congress in Article 1.8, so that the body closest to the people, a diverse group of people representing different parts of the country and different people, would set the policy, not the king, the president. So the Constitution says the Congress shall have the power to lay and collect duties, which is an old-fashioned word for tariffs, and the Congress shall have power to regulate commerce with foreign nations. So it's two separate, explicit, hey, Congress, you got this, not the president. Now, over the 248 years of Congress delegating authorities, there have been different ways Congress has said, okay, we've got this authority, but the founders gave exclusive authority to the president to represent us to foreign sovereigns, to negotiate internationally. This is the check and balance here. So we're going to delegate our control over the content of tariffs and trade policy with certain parameters so that they can do the talking to the other countries, and then we're going to make them come back and we'll approve what they did or not, depending. And there have been different methods of doing that, as my book lays out, 6 different ways there have been power sharing. In this instance, President Trump is just presuming, not even king, sort of godlike powers under this particular statute. The statute IEPA may or may not authorize some tariff authority, but it can't be constitutional given the clauses I just read.
Hang on for a second.
He's doing.
Hang on for a second. So, you mentioned your book, which again is The Rise and Fall of Fast Track Trade Authority. I'd love to actually hear one of those 6 ways that Congress has sort of legally delegated some tariff levying authority to the president. And obviously, we're going to spend the rest of the hour talking about the argument over IEPA, but it'd be really helpful to know, again, from a legal standpoint, when this has been done, how has it been done and how has it worked?
Well, in a way, even more important than those historic instances, I would say it's worth thinking about one of the arguments the administration is making now, which is President Trump says he needs this totally unbounded IEPA authority for the sake of national security. Yet there is a statute that is in the Trade Act of 1962, Section 232, under which presidents have been delegated by Congress for decades authority to use tariffs in the instance of some national security threat. And the difference between that and IEEPA is there's more process, there's more oversight, and there's some parameters. So, for instance, in order to do a Section 232 tariff, the executive branch, a president, it's a delegated authority, has to have a process of doing an investigation and proving the actual threat at hand, and then coming up with a tariff that is justified by that threat. Not a lightning bolt, a useful tariff tool.
Okay. Lori Wallach, hang on for just a second. This raises so many more questions about, the necessity to prove the actual security threat at hand. So we'll talk about that when we come back. We'll also check in with a longtime Supreme Court reporter about how the court is positioned to hear these cases. And so that's all when we come back. This is On Point.
Thanks for tuning in to Connecticut Public Radio.
Support comes from Amato's Toy and Hobby of Middletown, a destination for holiday gifts with an extensive curated collection of toys and hobbies featuring imagination-based activities for kids of all ages. AmatosMiddletown.com, Main Street, Middletown.
The most effective way to spy on someone these days, get access to their phone.
It is like your digital fingerprints, everything you do, everywhere you go. If someone has access to that, they know probably more about you than your closest friends and family members.
It's a tactic the Chinese government uses to oppress ethnic Uyghurs. That story next time on The World.
Listen tonight at 7.
Support for Connecticut Public Radio comes from the Connecticut Data Collaborative, connecting people and data for good. Visit ctdata.org to learn more.
Support for On Point comes from Made In, makers of cookware found in restaurants around the world, offering a carbon steel non-stick griddle for home use, designed for use indoors or outdoors, on a grill or over an open flame. More at madeincookware.com. And BetterHelp, committed to making mental well-being a priority and offering support in taking on everything life demands. With therapists available to communicate via video, chat, or phone at betterhelp.com/public.
You're back with On Point. I'm Meghna Chakrabarti, and today we are taking a preview, or getting a preview, of a major court case that the Supreme Court is going to hear an oral argument tomorrow. And that is over whether or not President Trump or any president has unrestricted and unilateral power to levy tariffs on behalf of the United States. And Lori Wallach joins us. She's director of the Rethink trade program at the American Economic Liberties Project and author of The Rise and Fall of Fast Track Trade Authority. And Lori, if you don't mind, I'd like to just nerd out a little bit more on the history here, because whenever we talk about the Trump administration or President Trump, as each year has gone by, I found it much more instructive to understand the implications of, let's say, a Trump-related court case if we understand how far the president's actions have deviated from what has historically been considered political or even legal norms. So with that in mind, it's so fascinating. I was just looking at Congress's own website, congress.gov. And if you just do a simple search for tariffs, the first hit you get is a very well-written web site all about U.S. tariff policy. And it says exactly what you said here, that over about roughly 70 or 80 years, Congress has increasingly delegated some tariff levying authority to the president. But it emphasizes through and through that it's Congress that sets the goals for the tariffs, but has given in some cases, the president the ability to negotiate those goals. And in fact, the congressional website says this is one of the things that has helped create a stable, rules-based world order when it comes to international trade. I mean, your thoughts about that?
Well, it's spot on, and you've found your right partner in trade nerdhood here, because the history of it is fascinating. And, you know, the book that I wrote talks about fast track. That was the most recent delegation. That was a much larger one than the previous. Congress used to very zealously guard this authority because they recognized the might of it. I mean, a president without using tariff authority, you know, exercising this massive power without care or based on corruption or whim or pettiness or political just judgment that could be questioned, could destabilize the U.S. and global economy and undermine the national interest. So Congress used to really hold on to this authority in these statutes that exist now, where there are legitimate delegations, including all of the trade enforcement laws, dumping, subsidies. There are parameters, there are checks and balances that are still remaining. And that's why this court case is so important with respect to this particular statute, because what the president is seeking is an entirely unleashed control. So it's not just going back to King George and having the ability as king to announce tariff authority, but the way that President Trump has used the tariffs shows really that's much more like a Zeus-like, God-like lightning bolt operation in that he's not even using it for normal economic reasons. So he ran saying that he was going to use tariffs to rebalance trade, rebuild American manufacturing, and boost U.S. industrial jobs. Those are all really important goals, which I actually share. I am not a tariff-phobic person, and I would contest some of even how you described who pays, because with this round of tariffs, actually, a lot of the foreign companies who are trying to sell us stuff are paying for all or some of the costs because we have such a lucrative market. That's the upside of having a $1 trillion horrible consistent trade deficit, is everyone needs to sell us stuff. So they'll negotiate on the tariffs. But putting that aside, tariffs can be a legit tool. The question is used how and for what purposes. And so you mentioned the 50% tariffs on Brazil. What's that about? We have a trade surplus with Brazil. We sell them more stuff. They're not part of our trade deficit problem that ostensibly President Trump's trying to fix. Why do they have some of the highest tariffs in the world? Because President Trump has unilateral authority, he thinks, to try and torment the current government because he's upset that they're trying to hold accountable the previous right-wing president who was part of a coup and had planned to kill most of the Congress and become a dictator in Brazil. And they're running a process there where they've sent him to court. He's been tried. He was prosecuted for this coup, as were a bunch of other people involved in it, and they're all going to jail. President Trump, like that guy, he's using tariffs to punish a country unrelated to our national interest in trade balance or manufacturing. That kind of whimsical use is precisely the kind of abuse or the corrupt abuses of tariff policy to leverage countries to make deals to help Trump hotels or Starlink or big tech. A lot of the leverage is to help big tech undermine domestic regulation of big U.S. monopolists as compared to creating jobs at home. Those are the abuses the founders had in mind when they said Congress, not the president, should have this authority.
Well, that the founders have in mind. You're creeping into originalist thinking here, Lori Wallach. I wouldn't have pegged you as a textualist.
Yes, well, what's funny is I actually think the weakest argument, the strongest argument for saying the president doesn't have these IEEPA authorities, and the weakest argument for the president is improbably actually a doctrine called non-delegation doctrine, which used to be used to try and undermine the FDR-era presidential powers that created the whole New Deal infrastructure and has not been used since. But it basically says if a delegation by Congress does such violence to some fundamental constitutional provision, check or balance, that it eviscerates it, even if Congress has given a delegation of that authority, it's still not constitutional. And in this instance, there's a lot of controversy about whether IEEPA actually authorizes tariffs at all or not. There are arguments on both sides, and we can go into them. But what clearly is the case is that if a president can use this unbounded authority the way Trump has demonstrated he does and will, then that cannot be constitutional given the checks and balances in the Constitution.
Okay, so I'm about to go through a thought exercise with you, Lori, and you can tell me if it's just too crazy and too disconnected from reality or not. But I like to push the bounds here. So with IEEPA, the International Emergency Economic Powers Act, right, which is 1974-ish.
Yep.
The act basically says, and I'm paraphrasing here, that the president has the authority to regulate international commerce, right? Doesn't specifically say tariffs, but commerce, in response to a declared national emergency. And the president is authorized to investigate, control transactions, freeze assets freeze foreign assets, impose sanctions, things like that, on countries or individuals, and here's some key language, that, quote, pose an unusual or extraordinary threat to national security, foreign policy, or the U.S. economy. Okay. So this is a trade and economic based act to protect the United States. But the phrase national security threat is the slippery eel here, because I'm thinking about this because we just had the news that former Vice President Dick Cheney died. I mean, national security threats, vaguely defined, the U.S. has used to start illegal wars, right, in Iraq. So, I mean, in a sense, we have already laid down the groundwork for presidents to use a vague national security threat to assume extraordinary powers not necessarily conferred to him by either the Constitution or subsequent acts passed by Congress. So why not IEEPA?
So what the court is going to do on this is a mystery, and there are two different ways they can go at it. They can look at the statute and contest or question whether there is a legitimate emergency, and or whether the language, because you didn't read this exact piece of it, but there's an exact quote, which is, it's an authorization for the president to regulate imports and exports effectively. That is specifically mentioned. The word tariff isn't, but the notion you can cut off all trade, because you can have an embargo under the statute. This is the statute Biden used, for instance, to embargo trade with Russia after the Ukraine invasion. Does it also then let you use tariffs, which is a way you can regulate imports? It's really the only way you can effectively regulate imports. That's the textual question, and they could go there. And then it's a question of, is there an emergency, and is there tariff authority? Alternatively, the court could look at some of these bigger doctrines, which is, even if there is tariff authority, and this might be an emergency, then can you have this kind of a delegation, and can it still be constitutional? And the question of how they're going to go, we're going to get the first hints tomorrow.
Right.
And, for nerds on trade and people who generally care about accountable governance, you can listen. The Supreme Court website has a live feed audio. So you can get a hint by what questions the justices are going to ask the parties litigating the case to see where different justices' thinking is going.
Well, I've also, in shows past, I've heard legal experts say that that oral argument is useful, but only to a certain extent, because it might indicate where the justices' thinking are going, or they just might be arguing for the sake of argument, but their thinking is much more strongly shaped by, say, all the briefs that are sent to them, or they're basically their legal philosophy on, in this case, presidential power. So Lori, hang on here for just a second, because this is a perfect opportunity, and thank you for setting it up for us to talk about specifically the cases that are being argued at the court tomorrow. One of the plaintiffs in one of the cases is a company called Learning Resources. It's a small family-owned business in Illinois that makes educational toys. And here's CEO Rick Woldenberg in an interview with CNBC.
When they were at 20%, he had promised 60%. We figured maybe he would land at 40%. But when it went from 20% to 145, it just went completely off the rails. It's 2.5 times what he said was the maximum. And it's way into the stratosphere that no business could possibly handle. We basically stopped importing at that point, which is obviously catastrophic. The business is built on flow.
And in another case, but also within the tariff umbrella that will be heard by the court, one of the plaintiffs is a New York-based wine importer called VOS Selections. Here's owner Victor Owen Schwartz in an interview on MSNBC.
You know, you increase someone's taxes 5 times, it's going to have an impact. I was just looking, I mean, our second quarter since the strangulation day tariffs hit, our profit went down like 60%. 60. Where's that money going? It's going to the federal government. It's a tax. So it's like all of us small businesses, we have this terrible anvil on our head. And you start calculating what's that going to cost us through the end of the year. Now that we have, you know, supposedly the set tariffs, 15% from Europe, 30% from South Africa. It's a challenge of cash flow it's hard to measure.